3M just agreed to pay $6.01 billion to settle the largest mass tort in history. Former U.S. military service members say they suffered hearing loss because combat earplugs manufactured by 3M subsidiary Arrow didn't work right. More than 260,000 service members sued 3M, and on August 28th, the company announced it has settled the lawsuits for a whopping $6.01 billion. While the amount's huge, the news was actually a relief for 3M stockholders, since some analysts had estimated the potential liability could have been $4 billion higher. Let's talk about these earplugs. What were the lawsuits about, and what's going to happen in the settlement? So first of all, what's wrong with the earplugs? Arrow Technologies made specialized earplugs for the military for use in training and combat. Arrow Technologies sold the earplugs to the military for 12 years, from 2003 to 2015. About 5 years into that arrangement, 3M bought Arrow. The earplugs were standard issue for service members in Afghanistan and Iraq. According to the lawsuits, the earplugs had two ends. The green end was supposed to be a traditional earplug that blocked all noise, but the yellow end was specially designed to protect against loud impulse noises like explosions or gunfire, while still allowing low-level noises like commands or approaching footsteps to filter through. The military purchased hundreds of thousands of combat arms earplugs from 2003 to 2015 and issued them to all deploying United States Air Force members. According to the lawsuits, 3M's own internal testing revealed defects in the earplugs. 3M did not commission an independent outside lab to conduct the testing, and the lawsuits claimed the internal testing was a sham. In fact, the lawsuit said that Arrow stopped testing the green end altogether because it failed so badly. The company continued to test the yellow end, which was supposed to test between 0 and 25 decibels. In fact, the suits say that the earplugs tested at a -2, which meant, ironically, that they were amplifying the sound instead of blocking it. Arrow concealed the poor results by telling the military that the earplugs had tested at 0. Arrow also put that false result on its marketing materials, according to the lawsuits. The suits go on to claim that Arrow launched an investigation into what was going wrong with the earplugs and discovered the green end was not working properly because it was too short to fit down into the ear for a proper fit and seal. Furthermore, the bottom flange on the yellow side interfered with inserting the earplug far enough to keep it from dislodging. According to the suit, the earplugs popped out just far enough to decrease the value, the usefulness, but not far enough that the service member noticed. The problems were even more acute in an actual combat situation where service members were more active. Since the yellow and green sides were symmetrical, the lawsuit says that once the company realized the green side didn't work, it should have realized that the yellow side would not work for the exact same reason, but it never went back and tested for the flange problem. The suit says the fix would have been relatively easy. The company could have enlarged or lengthened the yellow side and the green side, or increased the space between them. That's what the lawsuits say is wrong with the earplugs. But how did this case break open? The case began to break open back in 2016 when a whistleblower and his attorney filed suit under the False Claims Act. The whistleblower told the Department of Justice that the military was being sold defective earplugs that didn't work, and that 3M knew about the problems but was hiding them from the military. The Department of Justice investigated the case and concluded that the whistleblower was right. The earplugs had problems and that 3M had not disclosed those problems to the military. 3M settled with the government, paying the government $9.1 million. 3M did not admit liability. The government turned around and paid $1.9 million of its $9.1 million to the whistleblower. A special statute, the False Claims Act, allows whistleblowers to report fraud against the government and collect a percentage of whatever the government collects as a result. I've handled whistleblower suits for years, and hats off to the whistleblower and his attorney. The money DOJ got went to the military to cover the military's losses. It did not go to the service members who had lost hearing. Attorneys then began to file lawsuits on behalf of individual service members who had lost their hearing. Over the next years, nearly 300,000 cases were filed. According to Reuters, at its height, the earplug cases accounted for 30% of all federal court cases nationwide. By June 2023, the number of cases had dropped, but still sat at 254,943. The actions were transferred to Florida and consolidated as a multi-district litigation, or MDL for short. At 250,000 cases, the 3M earplug MDL was 6 times bigger than the next largest multi-district litigation. So what's an MDL? MDL stands for multi-district litigation, and it's what courts use to try to deal with large number of cases that have some similar issues. In an MDL, cases with similar issues are transferred to one central court to deal with the issues they have in common. For example, in this situation, all of the earplug cases were looking at whether the earplugs were defective, at what 3M knew and when, and at what it told the military and service personnel about the earplugs. An MDL is used to keep the courts from having to waste time litigating the exact same issues over and over in multiple different jurisdictions. One court handles the common issues. When the issues that the cases have in common have been resolved, the cases are returned to their original courts to try the issues that are different for each case. For example, although the 3M earplug cases had some common issues, the damages in the cases would have been different. Some service members might have tinnitus. Some might have minor hearing loss. Some might have major hearing loss. In theory, when the cases got returned to their original courts, 3M could have faced more than 250,000 separate trials. In practical terms, of course, MDL cases are often resolved en masse or at least in batches in order to keep them from overwhelming the courts, the lawyers, everybody. The plaintiff side and the defendant side here, 3M, typically pick some cases to try. Those cases are called Bellwether cases, and they are designed to test how juries are likely to respond to the cases in general. The parties use those results to figure out whether to settle and for how much. While the 3M earplug case was in the MDL, it took some wild twists and turns. The parties tried 16 different Bellwether trials. 3M lost 10 of the trials, but it won 6. Still, the trend had been toward the plaintiff winning more of the trials and winning larger dollar amounts. The average award when the plaintiff won was $20 million. In the final trial, Army vet James Beal won $77.5 million in damages for his hearing loss. Meanwhile, 3M was appealing the awards in the cases it had lost. When it became apparent the company could have significant liability, 3M tried to put Arrow and all of the potential liability into bankruptcy. U.S. bankruptcy judge Jeffrey Graham in Indianapolis didn't buy it. He said that Arrow was a well-supported subsidiary of 3M that had too much financial security to justify bankruptcy. He said there was no impending risk of insolvency and no reason to think the parties could not settle the case outside of bankruptcy. And so they did. 3M announced the $6 billion settlement on August 29, 2023. Even before the news was official, 3M stock went up 5% on rumors that a settlement was nearly a done deal. But if you're one of the 250,000 people with a suit in the mass tort action, don't plan on seeing any hard cash right away. The company says the money will be paid out over a 6-year period from 2023 to 2029. $1 billion of it will be in the form of 3M stock. 3M continues to insist that it is not admitting liability, and that the earplugs are safe and effective when used properly. The lead lawyer for the plaintiffs, Chris Seeger, said he expected 240,000 people would be eligible for the settlement. If you like content about the most interesting legal cases, subscribe and come back for more. And please hit the like button to get the video out to more people. See you in the next video.